Limited.
Mr. Strang.
My Lord, yes, I'm Mr. Strang. I appear for the appellant, together with my learned friend, Mr. Kyle Taklal Singh, from the Trinidad and Tobago Bar. And appearing for the respondent are Mr. Brent Hallpike, of the Trinidad and Tobago Bar, and Mr. Owen Roach. So this is my appeal against the decision of the Court of Appeal to dismiss the appellant's appeal against the decision of the judge to award summary judgment to the respondent and to order the appellant to undo works that she had done to her house. It was enough for the judge that the appellant admitted doing those works and hadn't obtained prior written approval for them, as was required by a covenant in her lease. The judge found that the appellant hadn't pleaded a viable defence and had no real prospect of defending the claim. And she summarily ordered the appellant to remove and replace all of the modifications to her house. And I say she was wrong to do so, and the Court of Appeal were wrong to dismiss the appeal. And I'll be concentrating on four main points today in oral submissions. The first is the question of standing. The respondent didn't have standing to sue on the appellant's covenants in her lease. The claim pleads that the landlord's interests in the property were transferred to the respondent by the lease. That pleading was plainly wrong, and the lease did nothing of the sort, and there never has been any such transfer. But the judge overlooked that.
They were clearly acting as agent. So
yes,
about that.
That's the most the respondent can say.
And if someone had applied to amend, if the point had been taken in the High Court, someone could apply to amend and we wouldn't have been bothered.
Yes, quite possibly.
And why couldn't we amend now?
Well, we'd have to amend the pleadings as well as the name at the head of the case.
I mean, everyone, it must be a completely typical case where you have a management company, which, I'm slightly surprised there aren't more cases where this happens, but surely yes. If someone had taken the point, it would have been amended and end of story.
Well, yes. But in the end, it's for the respondent to plead the proper case. And if the respondent's seeking summary judgment, summary judgment should be on correct pleadings rather than incorrect pleadings.
Well, in principle, that may be right. But the difficulty is that if you don't take the point in the court below, which nobody did until the amended notice to appeal, wasn't even in the original notice to appeal to the Court of Appeal, was it? But anyway, no. If you don't take the point in front of the judge, the opportunity that the claimants would have had to amend is lost. My question is simply, should you be allowed at this point to take this point?
Yes, I say, because there's a judgment against me, and it's wrong.
Well, if you weren't permitted to take the point, the judgment isn't wrong.
Well, I'll address it in more detail.
Yes, of course.
It's a short point.
Yes. The Court of Appeal didn't deal with it that way.
No, they didn't.
They dismissed that ground of appeal by relying on case law and statutory provisions that were simply not on the point at all.
Well, I can see that Holland Park hasn't got a lot to do with
it. As for the substantive issues in the pleadings, my second main point today, even if the respondent was entitled to sue on the appellant's covenants, the judge ignored the valid defence that the respondent had lost the right to enforce the relevant covenant in this case, which I say is the covenant requiring prior written approval before making alterations. And that's based on the appellant's pleading that the leaseholders of 10 other houses in the scheme had made alterations similar to hers without approval, and the respondent had not objected, had not sought to undo or to stop those alterations. The judge discounted that pleading as irrelevant. I say she was wrong to do so because it gives rise to a case based on the respondent's past conduct, acquiescing in repeated past breaches of the covenant. That gives rise to the defence that the respondents now are stopped from enforcing that covenant against the appellant. Court of Appeal dismissed that ground, or rather they ignored it. It seems to have found that the point wasn't before the judge, and she didn't have to deal with it. I say they were wrong about that, and wrong to ignore it. The third main point is that I say the judge wrongly found that the appellant had no possible defence that the respondent had waived the requirement of prior written approval in relation to the recent works that she'd undertaken. She pleaded the respondent had prior oral notice of those works, knew that they had started, and 2 weeks after they'd started, wrote to her, not telling her to stop, not requiring her to seek written approval, but asking her to keep the work within certain time limits.
But also asking for details of what works exactly were being carried out.
Asking for details of what works would be in the common areas, which is different, I say, from asking for details for the purpose of written approval. The point about the common areas was that there was a suggestion that the appellant had been misusing the common areas for washing equipment and washing away cement and sand.
Which of the letters are you relying on, or was it both? 18th of
The
November?
18th of November.
Not the 25th?
Well, that comes after the work has finished.
On
I
your,
thought
on
according
your
to
case,
her,
yes.
According to her, the work had finished by the time the 18th of April. That was it.
Right.
No, in her reply to the 18th of November, on the 20th, she said the work's nearly finished, and what remains won't cause any disturbance, which is why she declined to keep it to the hour suggested. But I don't base my case on the 25th, other than to say that comes after the work's completed, and it's actually the first time that the respondent says, stop, or proceed at your peril. And I say that raises the question whether the respondent, in good conscience, could, after completion of the work, enforce the requirement for approval, in particular by injunctive relief to undo the work. And I say that the judge dismissed that defence on what was a superficial analysis, and the Court of Appeal did likewise.
They do say, don't they, in the 18th of November, look, there's been no request
Yes,
for
they do.
permission.
Yes. No formal request has been made, yes.
And you say that's ineffective?
If they, well, I say that
Waiver
if they were
notwithstanding?
if they were to indicate that they were enforcing that requirement, I say they should be asking for the details of the works that are.
I see.
The requirement for written permission requires written details of the works so that they can be approved, right? And they weren't sought. I also
But you
say,
accept that written permission was required?
yes, by the terms of the fifth schedule of the lease.
It
Yes,
was not obtained?
yes. That's why summary judgment was sought and granted. But I say it's not as simple as that, my lord.
But in the final analysis, what's inescapable here is that if they had followed the proper procedures, the respondent would have unquestionably been entitled to summary judgment.
Perhaps on a breach, but not on mandatory injunctive relief. That's my fourth point of today.
On the basis that an injunction is a discretionary remedy?
Yes, yes.
Your fourth point is?
Well, even if the respondent was entitled to enforce the covenant, it remained an open question whether the judge should order all the works to be undone. And I say she was wrong to grant that relief summarily.
Well, what would have informed her discretion?
Well, many of the pleaded facts that she discounted as being irrelevant, for a start. In particular, the pleading that 10 other leaseholders in the same scheme had been allowed to make alterations without written approval and without subsequently being asked to undo them. That, to me, is highly material to the question of
In what way?
relief. Well, I should take your lordship
Yes.
to the case.
All right, but take your own time, Mr. Chairman.
Well, perhaps let's go to Chatsworth Estates. It does answer the question, I say, my lord. I was planning to deal with this in more detail.
No,
but
no,
I'm happy to-
do
No,
take your own
you're
course.
right, we've
Take
preempted
your
it
own
rather.
course. Take your own course.
So, well, those being my four main points, perhaps it would be a good idea if I went through the pleadings in a bit more detail, if your lordships would.
Well, you can take it that we've read those, but if you feel the need to.
Well, there are some points that I would want to make from them.
Well, the pleadings are not the claimant's finest hour, are they?
Well, no, you're right. Yes, my lord, yes.
Are they? Go on.
So they are in volume 1, it's page 204. Yes. So page 205 is the pleading on standing, and it's paragraph 4. 4A has to be irrelevant to standing, the claimant's articles of incorporation. 4B is the relevant one, and that's the one that's wrong. The lease didn't do anything of the sort. I'll look at that in more detail. The terms of the lease that are relied on, they're pleaded at paragraph 6, page 206, and the clauses of the fifth schedule, in 6B, 6, 9, 10, and 11 of the fifth schedule. And I'm using page 55, 54 and 55 for that one. So 6 is reasonable notice to your neighbour. 9 is not to make any alterations or additions without first obtaining written approval from the lessor. 10 is covenant not to permit nuisance or annoyance. And 11 is not to breach the provisions of the Planning Act. And then, going back to the pleadings, paragraph 7 pleads the...
You've got 15, haven't you?
Yes, there's 15 as well. It's not pleaded, but I did draw attention to that. Yes, that's right. So that requires the leaseholder at 15.1 to comply with the reasonable rules and regulations of the Townhouse Management Company, being the respondent.
And 20. I mean, the scheme is, it's not unfamiliar, is it? The scheme is that each of the lessees becomes a shareholder of the company.
Yes.
And did the defendant?
Yes, as far as
Whether she did or not, she's bound by 20 of the schedule, but she probably did, I imagine.
I don't actually know.
Okay.
Paragraph 7 of the pleadings at page 207, the Townhouse Community Guidelines.
Are we troubled with them? I mean, I'm not quite
No,
sure what
well-
their status is, but
Well, I was going to say that the status of them is precisely that, unclear. There's
but
no
I mean, we've got
pleading
a
as to
clear
when they were
covenant,
issued.
a clear covenant in the lease, so we don't
Yes.
really need the guidelines.
That's right. It's not a major point. I was going to point out that they're not clear as to when they were issued. And actually, when you look at the architectural control guidelines themselves, they don't in terms impose an obligation. They say this is what a guideline might look like in paraphrase. But it's not a big point because there's the clause at paragraph 6 of the fifth schedule. Paragraph 9. Breach is paragraph 8. Now, there are breaches pleaded of all the clauses and of the guidelines. For the purposes of the summary judgment application and for the judge's judgment, the relevant breach is the requirement for prior written approval. And then there are these particulars of works done and acts of nuisance and disturbance. And then the relief paragraph 13.
Now, am I right, Mr. Strang, if you look at paragraph 8, and that's a rather long list of
Yes,
particulars complained of, only some of them are the subject of the injunction?
that's right. We can relate them at 13C. 13C in the mandatory injunction. One relates back to 8K.
Are those the terms in which they were it was granted?
These are the exact terms in which it was granted, yes. 2 relates back to 8B. 3 doesn't relate back to any pleading of breach. It seems to be, it wants the Christmas decorations taken down.
Yeah.
4 relates back to 8K.
Yeah.
5 relates back to 8I. The doors relate back, at 6 relate back to 8J and H. And 7 relates back to 8G. And then there's this mandatory injunction at 13D, which I say is so vague as to be dangerous and unjust, but there are 2 items that are identified as being not in conformity, and they are the wall that was removed from the rear patio, and that relates back to 8J, and the internal modifications, they relate back to 8O, and it's a point I say that those internal modifications that are to be undone are never particularized anywhere in any detail at all. So 8O pleads other internal construction works, inclusive of adding rooms and changing the layout as approved.
But it's admitted that, isn't it?
It's admitted that works were done. Yes, internal works were done. Again, without particulars. So I say that the judge didn't know what she was ordering there. The defence is in volume 2. Particulars of breach are dealt with. So that's page 358 of the electronic bundle. I won't go through all the responses to the particulars of breach. They're from paragraph 15 to 34. And the key point is that she admits making the alterations that are alleged, but says they are, by and large, says they are consistent with other changes. She denies the allegations of nuisance and improper use of common areas. But the material, there are sort of 3 things I want to pick up on are, first of all, paragraph 22 and 23, which I say the judge didn't deal with properly. This is the alterations to the front door and the adding of a window to the kitchen. It's important that the appellant here pleads that work was done in 2012 with the knowledge of the landlord at the time, and it was never objected to. So that's paragraph 22, page 365, and that pleading is repeated in 23 with respect to the front door and the kitchen window. And then there's the pleading with respect to the recent alterations. And that's at paragraphs 8 to 10, which is page 359. In summary, before starting work, the appellant orally informed, she says, 2 agents of the respondent, Elizabeth Bassarat, the property manager, Ian McLean, who's a director of the respondent. Those conversations took place about a week before the work began. 26 October is when the conversation took place. The work began on about the 3rd of November. The respondent...
Accepting that this is what happened, you're not suggesting that these people actually said she didn't need consent?
No, it's not what's pleaded, no.
And she knew she did need consent. So, you put your case in estoppel and waiver, but how does it get off the ground if you can't say they actually gave any reason to think she didn't need consent?
Well, yes, I do. When you look at what happens when the work starts, the pleading is the respondent sees the work starting, knows that the work has started, and 2 weeks into the works, we have the letter of the 18th of November.
You're going to show us an authority which,
Well,
on waiver, are you?
the question is, is it conscionable? Is it conscionable for the respondent to enforce the breach of this particular covenant in these particular circumstances? That's the test.
So I need your consent to do something. I tell you I'm about to do it. You don't say, OK, that's fine. And I, by just telling you, fixed you with the duty to do something positive to stop me?
Well, it's perhaps not, but it all depends on all of the circumstances
Yes.
and all of the facts. Let's go through it in full detail then. Let's start with the letter.
18th of November.
So this
At
is...
some point you're going to show us your best case on this, I think.
It's a simple... The cases that I rely on are for showing the principle, which is that if... Well, here we go.
It's unconscionability, isn't it?
Yes, it's unconscionability. It's as simple as that.
And with it,
It's not quite as simple. Unconscionability is a terribly unsatisfactory test, you know. Because one
It's,
person...
Well, it's one that has been used.
I'd certainly be helped by having a look at your best authority.
Well, let's
even a
use...
textbook.
Just go
Or
to
a textbook.
Gafford and Graham is the authority that I say establishes the principle. It's at tab 7 of the authorities bundle, volume 1, and it's page 1297. This is a case where in breach of restricted covenants, the defendant started constructing an indoor riding school as a part of a riding school business that he ran on his land. And that was in breach of covenant. And the claimant complained about that, also about works that had taken place 3 years before. The claimant hadn't done anything about those works at the time, but he included them in his complaint when he complained about the further works, and perhaps what were the more significant changes.
It's the old works which are the subject of this case, isn't it? Because the judge had refused to grant an injunction about the riding school, hadn't he?
Yes, but both works were the subject
The
of...
plaintiff failed in relation to the riding school. It's the old works that he succeeded in.
Well, both works were the subject of judgment in the appeal.
Right.
The question was, the question in short was whether the claimant had acquiesced in the breaches, and the test was whether it would be unconscionable for him to rely on his full rights. The head note is useful, page 1297. So the test is unconscionability. Perhaps the last line of that on page 1297, as a general rule, someone who, with the knowledge that he has clearly enforceable rights and the ability to enforce them, stands by whilst a permanent and substantial structure is unlawfully erected, ought not to be granted an injunction to have it pulled down.
Now, that's relating, is it, to the works that were done in 1986 to the bungalow
Yes.
and the barn?
Yes.
It's not relating to the 1989 work,
No, that's right.
where he objected at a pretty early stage, and although the riding school had actually been built by the time he applied for an injunction, nevertheless he wasn't held to have acquiesced in that.
Yes. He wasn't held to have acquiesced in that, although he was denied the injunctive relief.
Yeah,
It was a change of use, wasn't it, rather than the building? As far as the riding school went, it was a change of use rather than the building. The building had been there for some time, hadn't it?
I believe that's right, my lord, yes.
Well, according to the first sentence, he started constructing this.
I thought it was built, but anyway, yes, you're right. It does look like that.
Yeah.
I think there were adaptations required.
As far as that was concerned, wasn't it simply an example of the refusal of a mandatory injunction to pull down an existing building?
Yes, for the later works. For the earlier works, it was an example of acquiescence, not
But
disentitling.
Was that to do with remedy rather than...
Yes, for the later works.
Because, no, for the earlier works, if you look over the page, you'll take us to the right bit of the case, but it's talking about the willingness to have damages rather than pulling it down.
Yes, I believe, my lady, that's for the later works.
Is it?
Yes. If we go to page 1304, here's where we deal with the earlier works. So there's a discussion of some of the findings, and the first two paragraphs under the bungalow and the barn. Then there's a discussion of whether there should be a difference between a legal and an equitable right, the answer being no. And then Lord Justice Norse applies the test from Shaw and Applegate at the bottom of page 1304, whether it would be dishonest or unconscionable for the plaintiff or the person having the right sought to be enforced to continue to seek to enforce it.
Mm-hmm.
Several years of general inactivity is the finding, is that right?
3 years.
The quotation from the judgment below, which is on 1304.
Yes, it's 3 years of inactivity, yes. And so the inquiry that Lord Justice Norse says one undertakes is in the middle of page 1305. I accept the facts are different in this case.
There's also the point that here the respondents are not acting for their own interests, they're actually enforcing this on behalf of all the owners of the estate. And it would be a fairly strong thing to say that simply because there was a conversation with these two officials, that means that everyone in the estate is unable to...
It's not the only factor that I rely on.
Yes. Anyway, this is your best case.
So, and this is in answer to my Lady
Yes.
Black's question. The last part of this section, you'll see, having gone through the inquiry, he says that acquiescence was a bar to all relief in respect of those matters.
Mm-hmm. So here the defendant knew about the works being done and made no complaint to the plaintiff until 3 years later.
Yes. I accept the facts are different. The facts that I rely on in this case, first of all, this letter is written 2 weeks after works have started. And well, let's go to the letter. It's page 374.
So you're talking about the 2014 works?
Yes.
Is that the same as at 106, Mr. Fran? I'm sorry, one or two things are in several places.
Yes.
374, did you say?
I believe it is the same at 106. Yes.
Yes, it is.
Yes. So this is 18th of November. It's 2 weeks after the work started, and the respondent knows that it's 2 weeks after the work started. That's said in the middle of the page. The verbal time frame given by you was 1 week. This is now the second week of construction. Possible inference there that if it had been 1 week, there would have been no complaint.
Well, the second paragraph tells us, well, they're stating in the letter there has been no formal request
Yes,
prior to the start of construction.
that's right. That's right.
So that's the very first point they make.
Yes. Verbal communication was made, and there's been no formal request.
And then the terms of the verbal time frame is preceded by of concern to this board also.
Yes, I accept that, my lord, yes.
Yeah.
But what does the letter say and what does it not say? The requests that are made are over the page 375 or page 107. Let us know the time frame. How much longer are you going to be? Because they're complaining that, the complaint is, you said it would last a week and it's already 2. I do say there's an inference there that if it had been quick, there wouldn't have been a complaint.
Yes, but where does that take you?
Well, it's about whether one can now enforce to the extent of requiring these works, all of them, to be undone.
Well, I mean, even if you give an indication that you might tolerate a certain amount of works, if the works persist, surely it doesn't deprive you of the right to rely on the terms of the agreement.
Well, I say it might deprive you, yes, my lord. Because all of the factors...
Why should it?
Because
the terms of the agreement are clear.
What the respondent is asking is that all these works be undone. And if the respondent's position was that works which markedly change the appearance of a house but happen quickly would not be enforced against, and works that don't change the appearance of a house very much but last for 5 weeks would be, then I say that is a relevant position for the enforcement of...
Well, I'm not suggesting that it's irrelevant, but what I am suggesting is that it's not a killer point. I mean, it doesn't...
No, not a killer point, but all of the circumstances need to be considered when one's talking about the conscionability of enforcing this covenant after the event.
Can we see what they say? Because they start by saying, look, no formal request, and they give chapter and verse why there should be. It may be the wrong chapter and verse, but they certainly give it, don't they? Then they say there are some other problems as well.
Yes.
And those are the bullet points. And then what do they say? As a result of the aforementioned, the board is formally requesting communication be made immediately. How should we read that? What are they asking for?
They're asking for the time frame for construction. Well, that's what they're...
Is that all?
Yes, and then they're asking for, number 2, they're asking for the expected work to be done in the common areas.
Well, why aren't they asking for a proper written request for permission?
Well, that's precisely my point, my lord.
Well, they are, aren't they?
Well, no, I don't say that.
You say not?
I say they're not, no.
Okay.
You read 1 on the second page of the letter as meaning that all they're wanting by way of communication is an outline of a time frame,
yes.
Rather than that they want communication to be made in accordance with the guidelines, which will also outline the time frame.
Yes,
Yeah.
I do say that. They're asking for that. They're asking, how long will this work? How much longer is there? Number 1. Number 2, what work are you going to do in the common areas? And that relates back to the specific complaints about
Washing the cement.
Yeah.
etc., which are...
Tiling the pathways and that sort of thing, yeah.
You know, on that reading, it might be said that they've made the point on the first page that there's been a failure to comply with the requirement to request approval, but on the second page, they appear to waive that by completely ignoring it.
Well, that's
your reading of it.
that's one of the readings of this letter.
Yeah.
That's what I say.
Okay.
And then number 3, I say enforces that. reinforces that reading, because it says, we're formally requesting that work be carried out during the following times. So in the interim, while we're waiting for this, this is a request that's to be carried out now. Mm-hmm. Just keep your work within these times.
So the right letter would have been stop now.
Yes, exactly. The letter doesn't say stop work. It doesn't ask for the details of the work in order to decide whether or not to approve. It's only asking for what work's going to be done in the common areas. It doesn't say lack of formal approval is going to render all of your work liable to be done. It doesn't say proceed at your peril. It says proceed, but within these hours. That's what I say the reading of the letter is.
This relates to the work which was going on at that time, but
Yes.
there'd been the earlier work as well. hadn't
Yes,
there?
and that's a separate point.
And what was the finding stroke evidence about when they knew about that earlier work?
No evidence, but an impermissible finding, I say. That's the judge's finding. I'll take you to that right now.
Are we talking about 2011?
To 2012. Well, the 2011 is a slightly separate point. So all there was in 2011 was an admission that the appellant had repainted the common gate. She admitted repainting the common gate and said she did so with the express permission of the respondent's then president and did it at her own cost. But the judge still awarded summary judgment and special damages for the cost of repainting it 3 years later. And that, in my submission, that has to be an error of law on the part of the judge, but it's a minor point in the scheme of things.
Given that this was a summary judgment consideration, one ought to look at the defence, as it were, at its highest. Does the defence assert when this work was finished?
The 2014 work? Yes, I say it does.
I'm sorry, I've lost it. I'm sure it's there somewhere. Oh yes, paragraph 11. Thank you.
Yes.
That's what it asserts.
That's
at any
right.
rate. That's what it says.
All completed by the 24th.
Yeah. Then she went to Dubai.
Yes.
Yeah.
And she did exhibit a letter from people who were at her Thanksgiving party on the 26th saying the house was nice and done up. There's no cement mixes around. I was just answering my lady's question
Don't let
about...
me take you out of your course if you're going to deal with it separately.
Yes, I am.
That's fine.
So, well, I think I was just making my points about the letter, and I say they do raise. This is a summary judgment application. They do raise the defence that it wouldn't be proper for the respondent afterwards to insist that the works must be undone, or otherwise insist on relief, because no written approval had been obtained. And that's to assess how those points that I've just made impact on the respondent's conscience would require a fuller factual analysis than is available on summary judgment. It requires trial of the evidence. There are questions: how much did the respondent know about the works in advance? What was the content of those oral discussions? It would also be relevant what work had actually been completed by the time of the letter, what work did the appellant do afterwards, and also what was apparent to the respondent at the time of the letter. It may also be, there's also the point raised by the defence that the appellant was at odds with some of her neighbours, including the chairperson and treasurer of the respondent. And there was an altercation between her and the chairperson of the respondent on the evening of the 18th, presumably after the letter's been sent.
So?
Well, if the respondent's position did harden after the 18th of November, what might the altercation have had to do with that?
We've got this somewhere in the affidavits, have we?
Yes, it's,
what does she complain of? Again, taking her case at its highest, what does she say happened on the evening of the 18th?
You'll see it in a letter that her lawyer sent on the 20th.
Does she say they were complaining about her work?
It's page 429.
Thank you. Does she say they were complaining about her work?
No, not.
Not?
No, they were complaining about other things. So page 429 is
I see, yes.
Page 429 is the account of what happened on the evening of the 18th of November.
Right.
And what's the relevance of that?
Well, it's in a list of possible factors that might act on having identified the points that I made in the letter, about the respondent's knowledge beforehand. There would be a list of possible factual inquiries at trial as to how the respondent's conscience would be affected by its conduct and its decision-making and its communications. And I say, if the respondent's position hardened after the 18th, there's a material factual inquiry in what happened in the altercation between the chairperson of the respondent and the appellant.
Are you saying that the letter could be, the reading of the letter could be illuminated by what happened on the evening of that day, because it might suggest that there was a reason to change the position thereafter, and
Yes,
that you would say therefore strengthens the reading that they weren't going to make trouble
Yes, that's one factor
earlier.
that arises, yes, my lady, yes. So that's just one of a list of possible factual inquiries that go to the respondent's conscience, including, as I said before, what it knew about the works, what was apparent about the works when it wrote on the 18th.
Remind me, when did the work start?
3rd of November.
3rd of November.
Yes.
So by the 18th, it's pretty well advanced, totally
Yes.
committed.
On the appellant's case, she'd nearly finished. She just had tidying up works to do. And I say the judge really didn't deal with any of those issues. Her judgment on this point is at page 5, dealing with this point, page 520. And summarising, it's paragraph 19 and paragraph 20.
Just give me that number again. What page?
This is page 520 of the electronic bundle.
Thank you very much.
That's paragraph 19. And the important factors for the judge are the appellant admitted receiving the guidelines after she commenced works. The lease, in any event, contains the same condition for prior approval, and the respondent ought to have known of her obligations under the lease. And as for the letter, paragraph 20, the letter indicated the respondent's displeasure at the construction works, and that was a clear indication there was no evidence of acquiescence by the respondent. Well, I say it's not enough to say the letter indicates displeasure. All the other things that it said and didn't say are material, as I've just attempted to set out. And the judge hasn't considered that. She hasn't considered any of the other factors that I've just enunciated. I say that's insufficient to deal with the real case presented by the letter and the respondent's conduct. Court of Appeal dealt with it in it's page 971. That's volume 3. So it's line 16. This is the Court of Appeal's judgment there, those lines 15 to 30.
Yeah.
That's
I
line
think
16.
we've all read that.
Yes,
Yes.
yeah.
Well, I say that's a superficial rejection of the appeal and all the points that I've made.
Well, an important point, important aspect of the Court of Appeal's approach was to say, well, look, what we need to focus on is the way this case was actually argued in front of a judge and presented to her. And the focus before the judge was on the 2014 works and the significance of the conversations and letters that passed at that time. And they said that looking at those, we're not satisfied that there was any acquiescence.
Well, I think one has to be careful about how the case was put to the judge, because the judge dealt with it on the papers without an oral hearing.
Mm-hmm.
And so when the judge says, I'm concentrating on these points, it doesn't mean that somebody concentrated on them orally before her.
But there are written submissions to the
There are
judge,
written
aren't there, which we've got at 484.
Yes, and the written submissions do raise the point about the other works to other houses, for example. Let's get the written submissions.
Well, there's a convenient summary at 497.
Yes. And there's a pretty good summary of the defence at 488.
Thank you.
So it's not just the letter, but also
No
The oral
oral
notice.
objections, yes.
yes, and also the point in the letter that isn't taken up by the judge and is rejected by the court. The Court of Appeal didn't want to hear the point that the letter asks for a time frame and asking for the works to be kept within certain hours. And that's the one part of the letter the court didn't want to hear Mr. Maharaj talking about. But yes, my lord, you said 497.
Mm-hmm.
Yes, that's right.
Paragraph 27 I was thinking of.
Yes. Well, it's rather compendiously dealt with at 27A, I have to accept, but the defence is set out, summarised fully earlier. And then there is the issue that's ignored by the judge and the Court of Appeal at C, whether the claimant turned a blind eye. No, that's not the one. There's another one. I'll get it.
37B.
I've got a reference for it somewhere.
37C certainly is other residents.
Well, yes, I had read that as saying whether the claimant turned a blind eye to alleged breaches, including those by other residents, but it says by the defendant from 2011 up until the filing of the claim.
That's 27C, but if you look at 37C, it is there.
Yes, that's the one I was looking for, yes, 37. Yes, this is the one, 37C at page 501. So, yes, 37A is no mention of the earlier breaches, no objection to earlier breaches, which was dealt with wrongly by the judge. B is the one about the letter.
Can I ask, in relation to A, we have an allegation here that the claimant turned a blind eye. Is that? Do we have any more said about that? What evidence is going to be?
Well, this is. I think that can be related to the alterations that were made in 2012.
Yes, quite.
Well, much more can be said about that, I say, because the pleading in the defence is that the landlord, Home Construction Limited, knew about them at the time and made no objection. But yes, I say there would. That would need evidence.
What does she say she did in 2011?
2011 was the painting of the gate.
Right.
And damages were sought to repaint the gate on the grounds that she'd
Right
done
colour.
it without authority.
Okay.
She said, I had the express permission of the president of the respondent to do it, and I did it on my own.
I mean, we can't,
Yeah.
I'd have thought the gate could be sorted out. I don't know what the other side is saying about that, but your point is she painted the gate. And
Well, the point is the judge
I know the judge
willy-nilly gave
seemed to
every
have missed
relief
out
that
on
was sought.
I can't believe we would come all the way to the Privy
No.
Council because of the gate.
Well, it's not.
Was it just the gate in 2011?
I believe so, yes.
Right.
But then there's 2012, isn't there?
Then there's 2012.
And that was more.
That's the door and the window.
Yes, but... oh, yes, I see, the door and the window.
And
And
those
the
are
Christmas
ones-
decorations and the leaks, but those weren't the subject of the injunction.
2012 works are set out where?
They are, let's get the pleadings, they are,
Try page 364, paragraph 22 of the defence.
yes, it's 22 and 23 of the defence, yeah. I don't need to show you the claim.
And she says with the knowledge of
Of the landlords.
the landlords and no objection.
No objection at any time until it's tacked on to the particulars and the mandatory relief in this claim.
So it's a
Triggered by-
small window in the... At least she says it's a small window.
there's a picture.
Yes, quite.
There's a picture.
In one of the doors, I'm not sure which. Or is it both?
There wasn't a reply, was there?
No.
No. Yeah.
And that work was included
No.
in the mandatory injunction.
First time that any objection is taken to that is in the particulars of claim.
Are those works included in the mandatory injunction?
Yes, it's included in the mandatory injunction as well, yes. Which is,
Where's the order?
the order's page 528.
Yes.
Thank you.
And the mandatory injunction is 2 Roman 5 and 2 Roman 6, page 529.
Sorry, 2.5 is the window to the kitchen.
Yes, that's right. That's the window that's the 2012 window.
Oh, I thought it was a small window and a door.
Yes.
Following so that you could see possible intruders.
That's the changing of the appearance of the door that was complained about. That's paragraph 22 of the defence. Paragraph 22 of the defence admits changing the door by adding a glass space to it. That's page 365.
Yes.
Then the admission of the kitchen window is the next paragraph, 23. A very small window was installed. That's the kitchen window. She says they were both done.
Are
in
we really
2012.
concerned? I mean, surely you could have got together and sorted out whether you need to change a window or not. I mean, I just find it extraordinary that here we are, 4 years on the Privy Council, discussing whether a window is changed.
I didn't want to make these a major part of my submissions, but it is an indicator of the judge's
Yeah, I mean, you've
lack
got a
of
point
care.
that the terms of the injunction went too far.
Yes.
And if that had been the only point, no doubt that could have been sorted out. Because, I mean, it's clear that the real complaint was against the major works that you did in November 2014.
Yes, but I still need to. I'm appealing against all that relief,
Oh, yes,
but I still
maybe.
need to make the points about this relief.
Yes, you're
And I say
maybe
it's
entitled to relief on that.
it's an indication of the judge's lack of care over this.
To what extent does the attitude taken to those older works contribute to what you say about the 2014 works?
It does, yes. It's part of the picture of a pleaded history of past works undertaken where no requirement for written approval has been enforced. And at some point, when the beneficiary of a covenant has acquiesced enough times in a breach like that, they lose their right to enforce it for the future. And that's the Chatsworth Estates point. So the defendant's own breaches in that regard and her fellow leaseholders' breaches in that regard are all relevant to that question. I think I'm just about to move on to that point right now. I think you said what I can say about the communications in November 2014. But this is the defence set out by paragraphs 13 and 14 of the defence, which is in summary that other residents had altered and extended their houses without approval, and the respondent had made no objection, taken no action against them. And that's page 361.
Yeah.
I would like to look in a bit of detail at paragraph 13 because the appellant lists and describes the work done by others, and she exhibits photos. And it's worth comparing them to the works that are complained of against her. So 13A. So concreting over of the hedge and construction of an extension. Those photos are 382.
382.
382.
Just so that we can do the comparison, what's the page number for the photographs of what she did?
Well, yes, 382 is the concrete done by
Yes, that's
Townhouse 1.
Yeah.
415 is the concreting over done by her.
Thank you.
Now, that's an instructive comparison there, I say. Because 382, nobody's ever asked 382 to Townhouse 1 to undo what was done at 382. But the appellant's being criticised for what she's done at 415. And then the 383 and 384 show the front and rear extensions to Townhouse 1.
Wait, which page?
383 and 384.
That's number one, is it?
So that's Townhouse 1, and that's the pleading at 13A. So 384, you'll recall that the appellant's being under challenge for taking down a low wall at her, changing her rear patio by taking down a low wall. Here's a patio changed by having a rear extension built over it.
What, the slightly sloping roof?
That's the
That's it, is it?
sloping roof of a rear extension.
I follow. All right.
And then there's 13B, which is construction of a shed at the rear of the property, installation of a new gate. So that's page 386. So this is... Now, the appellant's been criticised for putting up pillars on her porch and for changing the appearance of her doors. And here's a pillared carport and a new, different gate.
Sorry, 386.
386, yes.
And the pillars we're talking about on Townhouse 18 are at 417, is that right?
I've got 342 and 343. There's quite a good picture there.
Okay.
Oh, sorry, my lady, what was your reference?
I think 417.
417. Yes, that's right.
That's the front of number 18, is it?
Yes, that's the appellant's property. And then 418 is her door with a window in it.
But is 386 the rear or the front?
That's said to be the rear, I believe.
Yeah.
Must be, mustn't it?
And that's Townhouse 3, is it?
That's three, yeah.
Different style of pillar.
Yeah. Yes, in 389 it rather looks as though
And
the...
then
389 it rather looks as though the alterations to the rear are
That's right.
screened
This is-
from view by fencing or a wall.
So this is, yes, this is 380. Yeah, 388, 389. This is Townhouse 7. That's the substantial, that's a large rear veranda supported by pillars.
It's not the wall, is it? It's the veranda.
Yes, it's the veranda supported by pillars.
Which we've also got in 388.
Yes. So, well, here we have pillars and we have a substantial and noticeable rear extension, change to the rear. (13D).
I mean, it's very difficult, and you can't be expected to know, Mr. Strang, but presumably the front is approached by an access road of some sort, is it?
It's as I understand it, there is the houses are in a development. There are two rows of houses facing each other.
Yes. So they face each other across an access road or something of that sort.
This is where we see the carports at the front.
Yeah.
The hedged
Whereas,
carports,
and the back gives on to some other sort of land, I suppose.
Yes.
Okay.
Then there
There isn't a schedule or something. I mean, I find sort of going through all these and trying to note down which of these photographs are...
perhaps I should have done a schedule. I
Well,
apologise.
if you're going to rely on it, it would have been rather helpful. I mean, your general point is surely made by pointing to two or three of these.
Yes, my general point is here are actually 10 sets of alterations are listed by 10 different leaseholders in this scheme of 20.
And we don't have
All of which-
any explanation from the other side as to why these were permitted or whether they agree with you or what.
No reply. The pleading is none of these were done with prior approval and no objection or action has been taken against any of them.
But and that's certainly the pleading, and as you say, it's a summary judgment. We must take the defence as it stands, but quite different considerations might apply, mightn't they, to the front as compared to the back of premises?
They might.
Yeah. Okay.
But those are considerations
Which need to
that
be
are
assessed, you say?
triable. Yes,
Yes,
that's
okay.
considerations to be assessed.
Okay.
What was done to the rear of the defendant's?
She was asked
What was
to
the most major thing done to the rear?
She was asked to undo the removal of a rear patio wall.
Right. I'm comparing in my mind with the picture of the overhanging
Yes,
upstairs.
a good instructive comparison.
Have we got a picture of her one?
Well, we don't have that because it's just a wall that's gone.
Right, but it would still
It's a
look
low-
differently.
Yes. Well, we don't have a comparison between hers as it is and as it was when first built. Neither did the judge.
What's alleged? It's 8J of the statement of claim at 209. What's the complaint of her, mirrored in the mandatory injunction, I think, in this instance, is removal of a wall at the rear patio
Yes.
and installation of a second double door at the rear of the property.
We have a picture of that.
Oh, have we?
That's 337.
337.
Where's the wall gone
Well,
from?
maybe I've misunderstood. It may be just that in order to put a double door in, you had to cut out part of the wall to change it from a single to a double door. It's just occurred to me that I may have misunderstood what the pleadings were, because we don't get much.
See if we can see what the others have got.
Sorry, what is this a photograph of?
337 is the appellant's rear.
And what she's supposed to have done to it?
She's added a double door where there was a single door before.
Well, those veranda-type doors.
Yes.
But you think that the only wall that's gone, maybe just the bit that's been replaced by window?
It may be.
Door.
Yes.
Window. And that one we should compare perhaps with 389?
Yes, or with 397, where the patio's been filled in to create a rear extension.
394, is that what it might have looked like originally? I don't know.
389 shows a big veranda coming out over the patio.
Yeah.
397 shows the patio filled in to create a rear extension. Anyway, my point is, all these, the defence pleads that all of these are done without written approval and without objection, without being asked to undo them. Given that the material covenant said to have been breached in our case is the covenant requiring prior approval, the tribal issue raised is, can the respondent insist on enforcement of that covenant when it's allowed all of these works to take place without approval and without objection?
This is Chatsworth Estates.
Yes. So that's a defence against the enforcement of the covenant. But it also provides a defence against relief too, mandatory injunctive relief. Can the respondent insist on relief requiring the appellant to undo all of this work when all of the other works are being allowed to stay in place? So that goes to the question of relief. That's a defence against relief. It's certainly a material factor in the judge's discretion, one which she discounted as being of no moment to her decision.
But in terms of the substantive defence, I mean, I'm just looking at, we haven't looked at Chatsworth Estates. You want to take us to that?
Yes, Chatsworth Estates.
But, I mean, that talks about a general change in the character of the neighbourhood and so on.
That's a...
I mean, your client is not saying that these covenants
No,
cease to have any relevance.
No. It's not... The Chatsworth point that I rely on is not the general change point. It's the second point in Chatsworth. We'll go to that now. So that's tab 5. It's page 1270 of the electronic bundle. The head note is probably a useful background and a useful summary. Just at the last part of the head note, in order to keep their estate purely residential, the plaintiff's predecessors had imposed covenants preventing any house being used otherwise than as a private dwelling house. They or the plaintiffs had, however, licensed a number of schools, some blocks of flats, a hotel, and in certain exceptional circumstances, 3 boarding houses. And without their knowledge, about half a dozen other boarding houses were being carried on in the area, which, however, still remained mainly residential. You see at the top of the page 2 defences.
The decision is that these acts and omissions did not prevent the plaintiffs from restraining the defendant.
That's right. In this case, they did not. And we'll see the kind of assessment that Mr. Justice Farwell made in order to decide that. It's an assessment, I say, can only be made after hearing the evidence at trial. There are 2 defences that you see at the top. A general change in the character, that's not the one I rely on, or an allegation that the change was brought about by the acts or omissions of the plaintiffs or their predecessors. So, if I can take you through to 1276. The middle of the page, 1276, just coming to the end of the first paragraph, you'll see the judge says this is not a case of a general change in the character of the neighbourhood. It's hopeless to say the change in the character is so complete that it would be useless for me to give them any relief. He goes on to the defendant's real point. The defendant really relied on the acts and omissions of their plaintiffs and their predecessors as a bar to equitable relief. Then the judge gives his assessment of the plaintiff's enforcement of their covenants in general, how they've enforced them in the past. And over the page at 1277, he accepts that they're pursuing this relief in this case for good reasons, and they believe it will be detrimental to the neighbourhood. But he goes on to say whether they're entitled to relief depends on the exact effect of their past acts and omissions. And this is where he sets up the test. Now, as stated in many authorities, the principle on which this equitable doctrine rests is that plaintiffs are not entitled to relief if it would be inequitable to the defendant to grant it. In some of the cases, it's said the plaintiffs, by their acts and omissions, have impliedly waived performance of the covenants. In other cases, it's said that the plaintiffs, having acquiesced in past breaches, cannot now enforce the covenants. It is in all cases a question of degree. It's a triable assessment. It's in many ways analogous to the doctrine of estoppel. I think it's a fair test to treat it in that way and ask, have the plaintiffs, by their acts and omissions, represented to the defendant that the covenants are no longer enforceable and that he's therefore entitled to use his house as a guest house? The question that I say is raised in this case by the respondent's past permitting of alterations without approval is whether the respondent permitted to people to believe they didn't need written approval to make alterations.
Well, it would have to be a representation, wouldn't it?
By their acts and omissions.
Could be by omission, you say. But
Yes, by their acts and omissions. Have the plaintiffs by their acts and omissions represented?
But it might be different in relation to certain of the covenants, because that's where he's saying that he'd been worrying that
Yes.
it might be different
Yes.
depending on the circumstances.
That's right.
And that might be true here too.
Yes, it would, and I say those are matters for trial. So the example he gives here, he was troubled how to develop the test, because if you make the test too blanket or simple, then suppose the defendant turned his house into a butcher's shop. Could he say the plaintiffs have permitted residential flats, therefore they cannot enforce the covenants against me? And the judge said the answer would be no. So what he says over the page 1278, what's the real question for the judge? The question is really this. It's the top of 232 in the report. what is it fair to say that the plaintiff's acts and conduct entitle the defendant to assume as to his use of Bella Vista? Could the defendant reasonably say, having regard to the plaintiff's acts and conduct, they could not properly object to my using Bella Vista as I do? I say the questions raised in this case. If the appellant has seen 10 of her neighbours make alterations without written approval and without objection, that's what she says. Wasn't she entitled to assume that she could do the same? And would it be proper for the defendant for the respondent to single her out for this treatment?
He says somewhere, doesn't he, that you can't imagine that the fact that you treat some residents with consideration prevents you from enforcing your obligations elsewhere.
That's right. That's right, my lord. That's what he said at page 1276.
Thank you.
That's part of a careful assessment of the plaintiff's conduct in enforcing these covenants in the past.
I understand that, but on summary judgment, the question is whether it's arguable.
Yes, indeed. Yes. This is an assessment made after trial. And
it's quite a swathe of Eastbourne, is that right? We're talking about here.
which is why why the judge might be prepared to be forgiving about certain oversights. So that defence is raised on this pleading. How did the judge deal with those pleadings? That's at page 517. It's volume 2. It's paragraph 11 of the judgment, page 517. This is where the judge sets out what she says are the material pleadings of the defence. And I say it's a very, it's limited, wrongly limited. In particular, this is how she deals with all the pleadings that she hasn't mentioned. The last line of paragraph 11, this is how she deals with paragraphs 13 and 14. SSS, that's the appellant, also alleged several other issues, but to my mind they're not of moment to this matter. I just mentioned paragraph 13 and 14. I didn't actually take your lordships to paragraph 14 and emphasise the points there, but that's where the appellant says those works weren't approved, legal action's never been threatened, I've been solely and specifically targeted. And the only other time the judge refers to that pleading is when she talks about relief, page 526. And I say the judge got this badly wrong here at paragraph 34 on relief. It's the last few lines. The defendant did not see the need to treat with any of these reliefs claimed. She never denied that Rainbow Court was entitled to the reliefs claimed, or any at all. She spent all her time in the defence painting a picture of persecution against her. Well, it's true, the defence didn't plead a direct response to paragraph 13, seeking mandatory relief. But that can't be the whole answer. And the judge dismissing what she said as painting a picture of persecution against her is missing a very important point. if the appellant pleads, the respondents let others do work without approval, and I'm being singled out for treatment, that must be taken as an objection to the relief claimed, requiring her alone to undo all the work.
Well, is it correct to say, as the judge does, that she never denied that RTCL was entitled to the reliefs claimed?
She didn't plead a response to paragraph 13 or 14 or 15 of the claim. But I say that's not sufficient to say she didn't deny the respondent was entitled, for the reason I've just said.
Right.
It's not correct. Because if you've said...
Well, the whole gravamen of the appellant's case was that they weren't entitled to the relief.
Yes,
It was a curious thing for the judge to say.
I agree, my lord.
She's reciting the pleadings, isn't she? Yeah.
Now, Mr. Strang, we're going to adjourn for a few minutes now.
Yes, my lord.
Mr. Strang.
My lord, I was just been dealing with the Chatsworth Estates point and showing how the judge had wrongly discounted those pleadings as irrelevant.
Yes.
Court of Appeal, they also ignored that issue. That's volume 3. Well,
Where is it dealt with in the submissions in the Court of Appeal?
in the submissions in the Court of Appeal, it's in the oral submissions.
Well, anywhere.
Well,
Yes.
all we have is the transcript, yes.
Yes. There are some written submissions too.
Yeah.
Mr. Maharaj,
Mr. Maharaj?
certainly did take the waiver
Yes.
point.
Yes, you'll see it. The first thing the first time it's raised as orally as 939, where Mr. Maharaj identifies paragraph 13 from line 23 onwards,
Yes.
Yes, I see, yeah.
Yep.
and then he elaborates on that point when Madam Justice of Appeal Jones asks him what point does that go to, and that's over the page 940. Line 10, the question, line 13, the answer. Waiver as to whether they could raise that issue having had other people doing it.
Yes, he lumps together waiver, estoppel and acquiescence.
Yes, and one can be forgiven for this because the terminology is used.
Well,
sometimes
Mr. Justice Farwell accepts that it's put in
Yes.
different ways. What was Chatsworth referred to?
No, my lord. And then Mr. Maharaj he's asked by Madam Justice Jones at 946, you see in the middle of the page, line 25, I'm sorry, I don't have the pleading before me. Isn't your case just about the documents? And although he's already set it out, he sets it out again. No, it's not just. No, not just the documents. We went on to show with the other facts. And then he goes over the page. 947, line 14. He again refers to paragraph 13. But here he puts it as a waiver whether there was any change in the uniformity of the community.
Yeah.
Well, that's one of the factors, but he'd already, I say, set out the other factors. But it's Lord Justice Archie Chief Justice Archie, who is insisting with Mr. Maharaj that the only case on waiver or acquiescence was based on the correspondence. And that's at page 956. And this is the point that my Lord Reed made about it.
Mm-hmm.
But here he's describing it as an estoppel arising on silence, Chief Justice Archie. And then Mr. Maharaj goes, no, that was put forward. That case was put forward. Bottom of the page, line 36. What was done with, there was what, as the claimant alleged, with respect to other townhouses, the works which were being done without objection from the defendant. And over the page, Chief Justice Archie...
And the judge accepts it, look at the bottom.
Insists that there's a case in law that would arise, but he insists over the page that that wasn't the case before the judge.
Oh, I see.
He's wrong about that. That case was plainly in paragraphs 13 and 14 of the defence, and it was in the submissions on summary judgment, which we looked at before the break. My Lord Black helped me out at paragraph 37C, page 501, where the point was made in the submissions. But the Chief Justice is insisting that the case wasn't before the judge.
Well, yes, you get it eventually, don't you, lines 34 to 38. Counsel insisting on the passage in Chitty about silence and the judge saying, yes, okay.
But then when he comes to give the Court of Appeal's judgment, at page 971, it's line 21. Comment of the judge with relation to acquiescence in the way in which it was framed.
Yeah.
Obviously made in the context of how the case was. So the question of acquiescence by silence did not have to be dealt with. Well, if he's dismissing paragraphs 13 and 14 of the defence there, he's wrong.
Yes. And he's talking about acquiescence. You wonder if he really has in mind the point that you're making.
Well, it's a question to what extent the Court of Appeal engaged with that point.
Yeah.
They had one copy of the pleadings between them.
Yeah.
And not the letter until still fairly late on, by the look of it.
Yes.
Yeah.
There it is. That's why that's my point on the Chatsworth Estates point, and why I say the judge and the Court of Appeal were wrong.
Yes.
The other point I just wanted to address slightly more briefly is just the point about whether it's correct to make this kind of order on a summary basis. And I've already made the point that the judge, making that order, expressly discounted pleadings that were highly material to the question. But I also say, just as a general point of objection to granting mandatory relief in these circumstances, that the judge, it simply wasn't possible for her to be sure that she knew all the facts that were material to the exercise of her discretion. It's a discretionary remedy. I've included in the authorities Shepherd Holmes and Sandon. Volume 2 of the authorities, it's tab
13.
It's volume 1 of the authorities, tab 13. And This was a case where mandatory injunctions were sought on an interim basis, but Mr. Justice McGarry made an important decision of principle about mandatory injunctions in general, and asserted that there would always be a discretionary remedy. That's mandatory injunctions to undo, I should be clear, to undo work done in breach of a negative covenant.
It's fencing out mountain sheep, isn't it?
Yes.
Yeah.
And there's a distinction between stopping something happening
Yeah.
and from ordering it to be undone. And Mr. Justice McGarry's conclusions on the question of principle are at page 1418 of the electronic bundle 351 of the report. Takes a valuable passage from the decision of Mr. Justice Buckley in Charrington and Simons. And between B and C, where a mandatory order is sought, the court must consider whether in the circumstances as they exist after the breach, a mandatory order, and if so, what kind of mandatory order, will produce a fair result. You've got to take into consideration all the relevant circumstances, amongst them being the benefit to the plaintiff, the detriment to the defendant. Mr. Justice McGarry's restatement of that is at E and F.
Yes.
Must include triviality of damage, existence of disproportion between the detriment, etc.
Yes, and he's also saying, but it's not possible in any case to state exhaustively and comprehensively the factors that need to be taken into account. But it's always going to be a discretion. Mm-hmm. I think that those statements of principle still stand. So, yes, I do say that the judge couldn't, in these circumstances, be sure that she knew all the material facts, all the facts material to the exercise of her discretion. It would only be in a very rare case that you could make that assessment summarily without hearing evidence. This wasn't one of them. It would be wrong. It would be wrong to grant this kind of relief summarily if there was any chance that on a fuller understanding of the facts, the exercise of your discretion might be different.
I mean, this does suggest that even if you lose on all the other points, there's a question about whether all the things you were required to undo actually were of any benefit to anyone else. I mean,
yes.
Internal works.
Yes, indeed.
Shape of a door.
And here's the question whether the judge could possibly know whether they're of benefit to anyone else.
Yes.
When she didn't know what internal works she was asking to be undone, ordering to be undone. So,
Shepherd Holmes was dealt with on a notice of motion seeking an interlocutory injunction.
Yes.
And there was an affidavit or two with no evidence, is that right?
yes. So not that different from where we are. But the actual point in issue in Shepherd Holmes was whether the mandatory relief could be available on an interlocutory basis. And one of the arguments was, well, taking what Lord Cairns said, it has to be available, so why not grant it? That's why the principle was established applying to all mandatory injunctions, not just on an interlocutory basis, that it's always a discretionary relief. So that statement of principle applies generally, not just to interlocutory questions. I think that's all I wanted to say about injunctive relief. The judge couldn't assess the impact on the respondent or the appellant's fellow leaseholders, she couldn't assess the impact on the appellant of the relief she ordered.
It does help. How often common is it for a case like this to be dealt with purely on the papers without any form of hearing?
In Trinidad, I don't know how common. I've seen plenty of cases from Trinidad. It's the first time I've seen something like this dealt with on papers. Mr. Tacklerson says, not very often.
We have had quite a lot of, sorry,
No.
we have had quite a lot of cases which illustrate an anxiety in Trinidad that cases don't drift.
Yes, well, that's...
Put it as neutrally as I can.
Yes, I'm very well aware of that anxiety in general. But if Madam Justice Pemberton's anxiety to not let the case drift led her to unjust decision and unjust relief, then...
But I mean, your client obviously objected to that procedure.
I don't have the full details of the correspondence that led to the summary judgment being granted, because it was different lawyers at the time.
Yeah.
But there's nothing in the papers, nothing in the record that indicates the parties knew or invited the judge to decide it on the papers alone in their submissions.
Well, they put in written submissions.
Yes, but written submissions are put in as a matter of course in Trinidad.
That wasn't a ground of objection in the Court of Appeal, was it?
No. It may, as I understand it, yes, that's right. As I understand it, when the parties came back before the judge after ADR, Mr. Hallpike told the judge he was intending to apply for summary judgment. I don't know whether the judge's decision to do it, to grant judgment without a hearing, came as a surprise to the appellant's representatives. I just don't know. I did have other submissions on the question of standing. As I understand it, it may be that from what my Lord Carmouth has said, I don't need to convince your lordships that the respondent's real right was only to bring the claim on behalf of the respondent, on behalf of the landlord. Didn't have a right of its own. And I understand your lordship's point about the point being taken late.
Yes, we have your point.
Yes. I don't have any other submissions.
Could I just ask, though, whether you've looked at, in case it arises, on the footing you've just addressed, it doesn't, but we have actually now got the management agreement, haven't we?
Yes.
At 9/11.
Yes. And,
does that have any bearing on the standing of the company in your submission?
It simply appoints the company as agent. It doesn't have a bearing on that. It doesn't transfer it doesn't assign the landlord's rights.
What is the recital at D?
Well, yes, that's interesting, isn't it? The lessor has agreed with the lessees to hand over the property subject to the deeds of lease to those persons appointed by the lessees in an annual general meeting. What handover is quite ambiguous there. It could be handover management of the property or handover...
It's not the sort of term you would use for assigning.
No, exactly.
It does sound like management.
Yes, and that's the way I ended up reading it, because when one looks at the actual terms of the agency agreement, they make it plain that the townhouse management company is going to be enforcing the lessor's rights, not enforcing its own. So you'll see that 3A, the lessor continues to have the right to make amendments to the rules and regulations. The townhouse 3C, the townhouse management company, is to collect rents payable by the owners of the units to the lessor and hold the money on trust for the lessor. To make payments at C2, make payments of accounts properly incurred by or on behalf of the lessor. And at 6, the agreement's revocable. The lessor may terminate this agreement. So it can't be treated as an assignment of the lessor's interests or rights.
And doesn't give them an equitable right to the freehold,
No,
you say?
I can't see any provision that would, my lord.
Okay.
Those are my submissions.
Thank you very much, Mr. Strang. Mr. Tatlal Singh, is there anything you wish to add?
No, thank you.
Mr. Hallpike.
If I may begin with the last point on locus. And firstly, we would say that the High Court and the Court of Appeal, of course, conversely to my friend, was correct. In the locus point, Holland Park, my lords have read that, knows what we are dealing with, and it's at paragraph 100 of the decision, which can be found in the electric bundle of 1249. Which is at tab 4, sorry. And paragraph 100 can be seen at the electronic bundle of 1268, page 1268.
Yes.
My lords, in regards to the last point raised, which is the locus, which is 911 of the electronic bundle, the agreement. Rightfully so, my friend read 3A. I know it's a bad copy, I do apologize. 3C, but as well, 3D is of note on that same page. Recover through all necessary legal and/or debt collection any and all outstanding rents, fees owed pursuant to the deeds of lease, including all costs associated, charges incurred in recovery of same.
Sorry, where was that?
3D in the middle of the page 912, I do apologize.
Yes.
How does that help?
Sorry, please, madam.
How does that help you?
My lord, I conveyed to the court that this part shows that the authority of the townhouse community, the respondent, to act in accordance with the other townhouse owners, which is to recover all necessary legal, because my friend's point is that we don't have locus, we can't bring an action, we are an agent, which we have dealt with in our submissions. Our submissions can be found. I do apologize. One second, please, my lord. Electronic bundle. It's 1187. I do apologize. 1187 of the trial bundle, of the electronic bundle. You have a copy of the submissions, my lords?
Are you meaning your...
The respondent's
case,
case. The
yeah.
respondent's case.
yes,
Yes,
we have
Here.
it, and we've all read it.
yes, you have all read it.
Yes, read that.
I had a look at your paragraph 7
Of the submissions.
of the submissions.
Yes, please, my lord.
7A in particular.
Yes.
But I can't see what that... It doesn't seem to me to do what you say there it does do.
Yes, yes, please.
So which paragraph number?
7A.
Yes, of the document.
It is part of the claim itself where the lease is attached to the claim.
Yes,
Yes.
got that.
Is the lease at page 46?
Yes, please. Much obliged.
Which paragraph of it does what you say it does?
Page 46 of the electronic bundle. If I refer you to the claim itself, it was mentioned in the claim. About
It
the author.
was, and
Yes.
I followed it through from there.
Yes, please.
It was on page 14,
Correct.
but it doesn't do what it says there it does do, unless you can point me to the right paragraph.
I can do. I will do.
Good.
If you give me a moment.
Well, don't worry.
I will come back to that point. I
Yes,
do know
perhaps it's in your submissions. I'll have a look at page
It's at page
986.
49.
Well, there's a reference to the management company
Yes.
in recital D on page 49.
Page 49, that's it.
Yeah, but what does that do?
A member of the Townhouse management community.
It says that there is a management company.
Yes, and if I was going to refer
Managing the
you...
leasehold building scheme.
Yes. If I refer you to page 911 of the electronic bundle.
Yeah.
Specifically at the beginning of the agreement, where it indicates that HCL, Home Construction Limited, the lessor, and I'm just paraphrasing now, and further down, it indicates Rainbow Court Townhouses, and hereinafter called the Townhouse Management Company.
Yeah.
So Rainbow Court Townhouses Limited, as the respondent, is same and one as the Townhouse Management Company.
Correct.
Yeah.
But so what?
Sorry, please.
So what?
They were in charge of the townhouse community development, and in that regard, they're entitled and mandated to enforce the restrictive covenants of the property.
Mandated by whom?
Mandated by HCL, the previous lessor entitled.
Sorry, previous lessor.
Well, the lessor entitled, yes, please, the lessor.
They're still the same, they're still the lessor, aren't they?
Well, they are still the lessor. And that is why we deal with that new point raised of agency in our submissions as well.
Yeah.
That even if they were just an agent, they are entitled to bring the action.
It rather sounds as though, in returning to the point raised by Lady Black, notwithstanding what you say in your case, you can't actually point to anything in the deed of lease that mandates the respondents to deal with alterations to the houses, but you're relying rather on the agreement of...
And the guidelines.
The 2012 agreement.
And the guidelines, yes, please.
Okay, okay.
And as I'd mentioned previously, not to belabor the point, but at 3A, which is to enforce all terms and provisions of the deed of lease and the rules and regulations therein.
Well, supposing you have got the lessors, that's home construction, we'll say, supposing you have got their authority to manage this estate, which you clearly have.
Yes.
Do you say that gives you the right to bring an action in your own name?
Yes, we do say
rather
so.
than in theirs?
We do say so because...
What principle of law gives you that right?
We say it because of the management company having been in management of the property since at least by 2012 by that agreement.
Yes, but
they have been enforced all the rules and regulations of
to
the lease.
to whom has the tenant made the promise to keep these various terms?
They're not tenants, they're homeowners. as a point of correction.
Right.
Yes, the homeowners to the management company. And as you see in her defense, she's accepted as early as 2011 that the claimant at that time, the respondent now, was the one that she sought permission from to do, as we say, trifle, the gate works.
I understand the point on
Yeah.
not taking the point. Yeah.
Yes, the difficulty being raised with you is that obviously the appellant was a party to the lease,
Yes,
but the lease doesn't appear to, in itself, to give the respondents power to enforce its terms against her. That power seems to have been given to them by the 2012 agreement, but she was not a party to that agreement.
yes, she was, but that is why we say Holland Park is instructive in that regard, because if it wasn't assigned to the respondent.
Yes, but come on, in Holland Park, who were the claimants?
Sorry, please?
Who were the claimants in Holland Park?
Homeowners.
Who were seeking to, well, wait a minute, who were seeking to enforce the covenants? They were the owners, weren't
Yes.
they, of the house next to the place where the alleged breaches had taken place.
Correct.
And the question was, unless I misunderstood it, which is quite likely, the question was whether the covenants ran with the land or not. Is that right?
That's correct.
And the finding was that they did.
Yes.
Well, if the covenants ran with the land, the status of the claimants to enforce them went without saying, because they were the owners of the dominant land, weren't they?
Yes, that's correct.
That's all you need.
Yes.
But your clients are not the owners of the dominant land, are they?
But that is why we say we commend Section 12 and 67(1) of the Conveyancing Act, as well in assistance in that regard,
I see.
which is in the submissions, as well as page 3, well, 2 and 3, if Holland Park doesn't assist. May I continue, please?
Yes, sir.
The second point I'd like to deal with is the summary judgment aspect of it. And this morning, Instructed Attorney Robin Loyce handed up the case, the Sagicor case, the Sagicor Bank case, which was not included in the bundle. I informed my friend on the other side about the case. And several of my lords were present in that case, so I don't need to go over it again. And in regards to the summary judgment, I think 21, which you're very familiar with, is instrumental in this regard. And we say that is very akin and similar to this case before my law lords.
The decision in Sagicor is that if the defence accepts liability, summary judgment can follow.
But yes,
Do you say that this defence accepted liability?
we do say so. And if I could,
Certainly admitted doing the work,
yes.
but what's said against you is that's not enough.
Well, we say she has admitted doing the work,
Yeah.
and she has admitted knowing since 2011 that permission has to be sought to do the work. So it is incorrect, and I would go through it, that the work started November 3rd. She got the guidelines on the 5th of November. However, she proceeded to do work without written permission on or about the 3rd, and continued without written permission continuously till sometime on the 24th, even though the letter of the 18th. So if I may refer to the High Court decision at page 513 of the bundle. It starts at page 513, volume 2, and if I could go to paragraphs 18 and 19. First of all, in reference to her defense, it said, and my lords have seen paragraphs 18 and 19. I mentioned 25, 28, and 30 as well. My Lord, similarly, in the Court of Appeal decision at page 932 of the electronic bundle, it starts at 932, and if I refer to page 936, at line 22 onwards to line 25 on the next page, is discussed extensively about the written permission and the townhouse guidelines that was not adhered to. And as we know, the decision is on 971 at line 14. Where Chief Justice Archie gives his decision on the matter after this, dealing with the letters and the submissions of both parties. And the third point, whether the defense raises grounds to refuse an injunction. Again, the High Court decision is at page 513, and that's the electronic bundle, page 522, 525, specifically paragraphs 23, 24, and 25. The fourth issue that's raised
Can I ask you, if we're looking at the High Court judgment?
Yes, please.
In paragraph 26.
Yes.
Mrs. Justice Pemberton addresses the question of acquiescence arising from the failure to object to the construction works.
2011 and 2012.
Exactly. And she refers to Halsbury as saying that acquiescence is used where a person refrains from seeking redress when there is brought to his notice a violation of his rights of which he did not know at the time, which seems a rather narrow way of formulating it. But it goes on. She goes on to say this invalidates the present appellant's claim that the respondent is stopped from seeking redress against the 2011-12 construction, as it was only brought to their attention by another individual after the fact. Do we find that somewhere?
That is in the claim itself. My Lord,
in the claimant's submissions?
The claimant's claim.
The claimant's claim.
And statement of case.
Right, thank you. Really? And statement of claim.
Yes, please. And the fourth issue, and I will then deal with the submissions as my friend has submitted.
Where's that?
Sorry, please, ma'am.
Statement of claim starts at 204, I think.
Yes, please.
But if one's talking about granting summary, if one's considering granting summary judgment, you're looking really at whether there's a realistic defence. So one tends to be focusing mainly on what the defence says rather than what the statement of claim says. Now, did she accept that that the respondents hadn't known about the earlier construction works at the time?
Well, what the position of those earlier works was to show a history and a pattern of the appellant. So as rightfully, the injunction was only solely on the basis of the 2014 works. And that was the main objection. Those were just to show a pattern of things that have transpired on the compound itself.
But the remedy that you were seeking wasn't confined to the 2014
No, it was not.
works.
No, it wasn't.
But forgive me, Mr. Hallpike, where is it in the statement of claim that the management company says that it didn't know about the 2011-2012 work until later?
Well, at paragraph 8, which is 208,
Sorry, paragraph
8,
8, yes,
which is a 208,
yes,
they refer to the breaches
Yes.
of the covenants. And then in the defense, at paragraph 31, which is page 368, is where we get the information with regards to those. And
yes, forgive me, I didn't ask the question clearly enough. Where in the statement of claim does it say we didn't know about the 2011 work until some time later?
I do not have that reference at this
Well,
point.
it doesn't, does
No,
it?
it doesn't. I
So-
would concede it doesn't.
How did where does the proposition?
It is possible from the application for summary judgment
Maybe.
and the affidavit in support of it, because there were two affidavits from the instructing attorney and the chairperson at the time.
I
So
see.
it might have been derived from that. So as we are on that note, it is incorrect to say that there was no application for summary judgment. Of course, there was an application in support of affidavits, in support of, and submissions before the court. Hence why she granted the summary judgment application. And there was, of course, opposing submissions by the defendant at the time, the appellant.
Yes.
It might be in that.
I mean, at some stage, I'm not suggesting you look for it just now, but when we adjourn in 20 minutes or so, you might like to try to find, if you can, the document on which the judge based her statement.
Yes, please.
That the earlier construction works were only brought to your client's attention
I will do.
after they'd taken place, because that's the basis on which she effectively dismisses those works and then goes on in paragraph 27 to focus on the 2014 works.
Yes, please.
instead.
I will do
So it's
so.
quite important for us to know if she had, in reality, a proper basis for what she said in paragraph 26.
Much obliged. Well, the fourth issue, as I see, is raised by the court is if the defendant identified any other grounds. And the same paragraphs that my lord was referring to is paragraphs 27 and 28, which can be found on page 524, is that the judge did deal with the other grounds raised by the appellant. And so too, of course, the Court of Appeal. 524, which is 27 and 28.
Where do you say she dealt with the implications of the works carried out by other
Well,
householders?
we say they're not relevant because we say this is an allegation raised by the appellant that these works were not sought approval. There's no evidence before the court, the High Court, nor the Court of Appeal with that regard. And the works had been...
That's because you went for summary judgment.
Yes, because...
She's raised issues about these other works having been done, which were comparable, and which were accepted without objection. And she relies on that as showing a degree of acquiescence. Now,
we say
the
the
judge
works...
doesn't deal with it.
We say the works are not relevant. These works that are referred to, that are done by persons, are in the back, rightfully so, it was pointed out. And we could go to the pages with the photographs. The works that are in contention, that is, we say that is in breach of the covenant, is the pillars that are in front. And as I said,
You're not only going for the pillars, you're going for all the work she did.
well, the wall in the back, which I will refer you to those pages where it only shows one of the double doors. There's actually two double doors, so we're saying it's a load-bearing wall that is removed. So it's incorrect to just refer to part of the photographs.
But I mean, it must be relevant, mustn't it, that your clients have not objected to certain changes being made to properties.
It's in the
I mean,
guidelines
you
that...
may have a point that these were much more obtrusive, in which case that would have to be argued about, but you can't condemn all her works if in fact they're similar to works which you've approved on other properties.
But none of the works are condemned for the back for any of the homeowners. The work that is being condemned is the work in the front with the pillars, because none of them have works similar to the appellant with regard to change in the front of the townhouses. And that is instrumental because that is what happens and happened in the High Court and the Court of Appeal. That you go out, and it's happening here this morning as well, or this afternoon, with regard to the other works are not relevant to the works that are in the front.
Well, you sought an injunction
Yes.
to have the doors at the back of the property removed.
Because yes, and if we go to the page with the injunction. So at J,
And to have the wall that was...
209, removal of a wall at the rear patio, installation of a second double door at the rear of the property. So it's not that a double door didn't exist before, but it's the removal of the second wall, the second piece of the wall for a second double door, which we say interferes with the structure left and right, which is 17 and 19.
Yeah.
Where
The integrity, the same J, it says removal of a wall.
Second double door, yeah.
Second double door. And that is the instrumental part of why they sought that as part of the injunction.
Yeah. The injunction that was actually granted requires the removal of structures on the external part of the house, which are not in conformity with the layout as approved or change the uniform appearance of the houses. And they include, the second one is pillars in front and the back of the property. And
Yes.
6 includes doors at the front and at the back of the property.
That is correct.
So the point that is being put to you is that it appears from the photographs that the claimant was arguing, with the support of photographs, that there had already been quite a lot of alterations made to the rear of other properties without objection, and that could give rise either to the conclusion that the obligation had ceased to be enforceable in relation, at any rate, to alterations to the backs of the properties, or it could give rise to a factor that would be relevant when considering whether a mandatory injunction was the appropriate remedy in relation to those alterations.
I do understand, Madam. But the point, I'll refer it to after the break, but the rear of the properties, all homeowners had the right to adjust or change or alter. It's the front that has to be maintained, the integrity and the similarity.
Well, if that's right, that would imply that parts of this injunction shouldn't have been ordered.
Well, the reason for the injunction for the rear of the property is the second double door, which is not in the changes that ever change in any of the other townhouses. And that is where we say that affects the integrity of the property, because you've removed the load-bearing wall. And in that regard, you have done something that you need permission for.
Right. Now, just, again, not now, but after lunch, would you show us where you said that?
Yeah.
Yes, please. Sure.
In writing?
Yes.
To the judge?
Much obliged.
Yeah.
So, if I may begin with responding to the submissions for Mr. Strang. His first point was that the respondent has no standing. There's no transfer by the leaf, and it acts as an agent. This point, rightfully so, was not taken in the High Court. It was not taken in the Court of Appeal. And rightfully so, as my lords had indicated, there was an opportunity. If it was taken, it could be amended. So even if he goes to the strongest point, perhaps, of being an agent, we say that instrumental is the agreement. Instrumental is the decisions that were taken by the townhouse community prior. And of course, we say if there was any acquiescence, the acquiescence by the respondent. Because she admits in her defense, and I'll take you to paragraph 31, which is on 368 of the bundle, where she admits, she says, sometime in 2011, I do apologize, sometime in 2011, the defendant was granted permission from the president of the claimant, Mr. Melville Wayne, to perform maintenance works on the compound. So she knew since 2011 she had to get permission. Then, instrumentally, if you go back in her pleadings at page 364, which continues on to 365, it's paragraph 22, and at the middle of the paragraph on page 365, this modification was done with the knowledge of Home Construction Limited and was never objected to in 2012. which she says the landlord. Previously in 2011, the claimant was the right person to get the permission from. But then, curiously, she says in 2012 she had to get permission from Home Construction Limited, which we don't know by her pleadings when in 2012, because we know it's the 5th of March 2012 is when the agreement was signed. And that same paragraph 31 is where she admitted that permission needs to be sought.
Yes.
Just for sake of completeness, we say that her referring to the 10 other homeowners, none of the other 10 homeowners has done or made alterations to the front of the property like the appellant. And we say that is irrelevant, and it, of course, it puts a spin on it, and you're thinking you have to concentrate on that, which we say shouldn't. And refer to the letters of the 18th and the 25th. And if I could go to that letter.
Yes. Yes, the first one's at page 374.
Yes, please. Much obliged. 374. The first letter of the respondent, we say have to be read in conjunction with the other. One page is not separate from the other. Whilst these are lay persons, homeowners, that have written a letter to another homeowner, and the tone is as such, they're living in a community, and then when you read it, it says, second paragraph, verbal communication was made between yourself and one member of this board. There's been no formal request. And I pause there, because in submissions, they're saying on the next page, it says, as a result of the aforementioned, the board is formally requesting. The only thing formal could mean is written. It can't be a further verbal communication or verbal request or permission to do any works. So it is not right to separate the two pages and separate what the townhouse community was trying to communicate, maybe not eloquently. And of course, if you don't know what the construction is going to do or what is being done, how could you give permission? And of course, the letter that was not being dealt with was the letter of the 25th, which is a letter from the attorney for the respondent in regards to indicating the position that has taken, and if you don't cease the operation. And we go back to that. There's no timeline given. There's no indication of the construction that is supposed to be done. So there is no way that the respondent could know what is to object to or what to grant permission to. My Lord, Mr. Strang made point strongly about the injunction and is vague and unjust. It matters not at this point in time that if the injunction, a discretionary measure by the judge, maybe she overextended, perhaps she was unrightly gave an injunction too broad or too much. But that matters not. What matters is the beginning of the matter is whether the written permission or not. And in that regard, it was right because there was no written permission, because there was no understanding of what was going to take place and how far this construction was going. They were right to take an injunction against the appellant. And with reference to it not being particularized with regards to what the injunctions are for or what parts of the inside were affected. The reason is not particularized. This is the inside of a homeowner who has not granted permission or who has not been availed to be able to take pictures or to know exactly what is transpiring inside of the property. So there was only to say that there were alterations being done internally, or there was the alterations at the back where it is we get to 8J, the removal of the wall for a second double door. If I referred, my lords, to page 358 of the electronic bundle.
Sorry, what page, please?
It's page 358, starts the defense.
358, thank you.
And I will go to page, paragraphs 15 and 34, my friend had alluded to. And specifically, I would like to go to 359.
Yes.
At paragraph 8, admits receiving the copy, and I've touched on this briefly, admits receiving a copy of the townhouse guideline on the 5th of November, some 2 days after she had already commenced works on her property.
Yes.
And still, after the 5th, did not seek written
what's the
approval.
relevance of the guidelines? I mean, there's a clear clause in the lease which says she must get approval.
Yes.
But the guidelines, I'm not sure what their status is. Do they?
The guidelines are flowing from the lease. Guidelines were prepared and given to all the townhouse owners.
I know, but are they binding in any sense?
Yes, we say.
By virtue of
By the management company, there are guidelines that anybody living in the compound or living in the community, the guidelines guide you to how you
I can see they could be advisory, but what is the legal basis for saying that she's bound by the guidelines?
Sorry, please?
What is the legal basis for saying that she's bound by the guidelines?
As one of the townhouse owners, the management company binds the other townhouse owners, and you have to follow the guidelines.
Try page 57, paragraph 15
Much obliged.
of one of the schedules of the lease. But it doesn't actually matter, Mr. Hallpike, does it? Because it's all in the lease anyway.
Yes, exactly. Yeah, 15 Roman numeral 1 and 2.
Yes, correct.
So these are rules and regulations, are they?
Which comes from the lease itself. As I say, it's part of the lease as well. So
I can see if you have rules and regulations made under 15.1, fine. Anyway, it doesn't matter, as my lord says, because
much obliged.
it's covenant.
So my friend went on about the estoppel point. And as we know, the estoppel point, it is only 2 weeks after the board has written. And it's not like 3 years as the case that he is referred to. And we say that that estoppel point doesn't even, and it's dealt with in the High Court and the Court of Appeal, where you can't say that the respondents are stopped from stopping, if I could use that word, the appellant from doing the works that she was doing. The unconscionable bit was considered in the High Court, and so too the Court of Appeal. I don't need to remind or go back to that again. And we dealt with Sean Applegate in our submissions. And as admittedly, Mr. Strang said, it's different facts.
The point that is made against you on the unconscionability issue is that the judge needed to know the detail of the evidence that sounded on the question of unconscionability, and that it wasn't open to her to reach a decision without examining those issues and the impact that it would have on the propriety of giving a mandatory injunction.
But we say it was open to her. We say that it wasn't unconscionable for the respondent to take the action they did. And it is on the papers, that is why the summary judgment did. There was affidavits filed, there was an application, a summary judgment, submissions made. And we said it was sufficient on the papers to see that she could have made that decision. And it was her discretion, which was upheld by the Court of Appeal.
Well, on summary judgment, she'd have to say, wouldn't she, that it was never going to get off the ground.
But that is what
you say. That is what she said.
That is what we say. It would have never gotten around. You have admitted it in your defense. You have admitted doing the works. You have admitted that it's in breach of the covenant. So how do you turn around now and then later on you want to say the locus, now you want to say another point taken. We are saying that it was dealt with sufficiently by the High Court and to the Court of Appeal. And my friend's point about perhaps the letter means you're only going on for more than a week. If it had finished in a week, maybe it would have been allowed. And if it was 5 weeks, it would not have been allowed. That's not the case. The whole point of the letter is that you did not seek written permission. And that is the whole crux of the matter, is that written permission was needed and should have been sought for enabling you to do the works you wanted to do.
Well, why was there any discussion at all about the timing then?
Sorry, please, my lord?
Why was there any discussion at all about the timing? Why was there a prescription laid down as to the hours during which work should take place? I mean, if it was simply a question of the instruction to the appellant to refrain from this work, there didn't need to be any discussion about the hours during which it might be conducted, did there?
No, but there was discussions. But of course, the work continued, and they didn't know when the works was going to stop. Hence, the involvement of an attorney. And still then, it was still ignored. Say, I've completed the works, or I've practically completed. There's no need for this. But it still goes back to the beginning stage, which is that the written permission was needed. She says that the works finished at 24th of November 2014. But who was to know if the works would continue? Because the letter from the attorney is the 25th. And she responded thereafter saying that the works were finished. No one knew what was the schedule, what was the timeline, how much works were going to be involved. All we know, there is a change from no pillars in front of any of the townhouses to 4 pillars in front of us. We don't know where it continues. That point about the letter at odds with the chairperson, that is, again, a red herring and irrelevant. It matters not what a discussion between a homeowner and the chairperson. It still goes back to the same thing, and I'm belaboring the point, but she did not write the townhouse community. And I commend again the Sagiko case that is relevant to this.
Yes.
Just before we leave the letters, there's the one of the 25th of November.
Yes.
Which is at page 92.
Yes, please.
I think, which you wrote on their behalf, didn't you?
Yes, I did.
But even that one is saying, we are formally demanding, it's on page 94 of it.
Yes, I have it.
We're formally demanding a written request.
Yes.
And it is to include the time frame, and then in the large paragraph at the bottom, until you comply with the above demands and or have received permission, you are to cease.
Yes, because at that time, even the respondent, nor the instructions receiving the respondent to myself, are unknown or unaware whether this would continue and when it would continue, and how it was to be continued. And still reiterating the point that please provide us with written requests for your construction of what you're doing so that we could know if to deny or accept.
Now, I wonder, Ms. Hallpike, if that might be a convenient...
Sorry, please?
I wonder if that might be a convenient moment for us to adjourn.
As my lord's wish.
Fine. Well, we'll sit again at 2 o'clock.
Much obliged.